Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. What if I told you that somewhere between 70 to 90% of most business transactions fail to deliver their expected value? It's a well-known fact, but it's a staggering failure rate. A primary reason that deals go sideways is poor due diligence. An acquisition that looks like a golden opportunity on the surface can easily hide liabilities that could destroy your business or cost you a significant amount of money in the long run. As a small business lawyer, I have extensive experience helping clients buy or sell businesses and helping guide them through what is often one of the biggest transactions of their lives. There's no crystal ball, but taking certain steps can help you minimize the risk. In this video, I'm going to share some of my secrets for acquisition due diligence from a small business perspective. I'll walk you through the strategies I use to protect my clients and how you can spot the red flags that many people miss. And please, if you'd like to get more helpful tips from us, please hit the subscribe button below and ring the bell to get notifications of when our next episode is posted. Let's get to it. The biggest mistake I often see is treating due diligence like a formality that does not need to be taken seriously. That's the fastest way to miss a critical risk that can cost you money and headache over the long run. The purpose of due diligence is to investigate a business to make sure it is worth the investment and does not have any hidden risks or liabilities that will destroy the business after you've paid for it or cost you a lot of money and heartache over the long run. The key to conducting good due diligence is to be focused and clear about what you're asking for. Ask yourself two questions. The first question, what am I buying this particular business for, and what assets are essential to the success of this business? Are you buying for market access, proprietary technology, operational synergies, or reliable cash flow? Your objective dictates the focus of your investigation. An acquisition for technology demands a deep dive into intellectual property filings. A purchase for market share requires you to scrutinize customer contracts and sales pipeline data to make sure that these contracts will transfer to you and you'll be able to take advantage of them over the long run. The second question you want to ask yourself is, what are the short and long-term risks for this business? Does most of the revenue come from one or two big customers? Is the intellectual property adequately protected? Are there key employees and are they sufficiently compensated to make sure they stick around for the long run? And so on and so forth. There's lots of things you want to know about a business. Different businesses have different risks. So you want to understand these risks before conducting due diligence to make sure that you obtain the right information to evaluate the risk. Your due diligence strategy should focus on determining that the essential assets you want are in good condition and that the business owner actually owns them, and that the business owner has taken steps to mitigate the risks that could harm the business after you own it. The process of due diligence should be kick off the moment after a letter of intent is signed, and you should be obsessive about organization. Time is a key factor in all due diligence because you often only have a set period of time to do it. Consider setting up a virtual data room to keep everything organized and that is shared with all team members involved in the due diligence process. This will make it easier to keep track of everything and keep everything organized and shared with everyone who needs to see it. I will now talk about some of the key areas of acquisition due diligence and what you want to look out for in connection with them. Probably the most important area to investigate is the financial information of the business. This is the heart of any investigation. The company's financial records provide a history of its performance and are crucial indicators of its future viability after you buy it. A misinterpretation here is the quickest way to overpay or buy a failing enterprise. Your objective is to uncover the objective financial truth of this business so that you're protected after you buy the business. First, you want to obtain at least 3 to 5 years of tax returns and financial statements. You want to obtain the profit and loss statement, the balance sheet, and cash flow statement for the last 3 years. A thorough analysis is required. Use an experienced CPA or other financial analyst to help you analyze the financial information to make sure that the business can support the asking price you're paying. You also want information that's current. So although not completed, you want to get pro forma financial statements for every month and quarter year to date. These can be generated by QuickBooks or whatever accounting software the business uses. It doesn't really matter. You just want to have the most up-to-date information that the business has to make sure it's profitable and that it's still conducting business in the same fashion it's done in the past. Here are some of the key things you want to look at in connection with the financial information you're receiving to make sure that the business is a sound investment. The first key area to look at is the source of revenue for the business. Where does the revenue originate? Is it diversified, or is the business dangerously dependent on a few key customers? High customer concentration is a major risk factor that must be mitigated in the purchase agreement. To protect yourself in these situations, you should ask for some type of escrow or holdback amount for part of the purchase price to be withheld to make sure that if the customer walks, you don't have to pay as much for the business. The next key area you want to look at is the consistency of revenue for the business. Is the revenue consistent every year and showing an upward growth path? Inconsistent revenue is a potential red flag, and you need to investigate further if the business you're buying does not show consistent revenue growth. Be particularly wary of explosive or out of the ordinary revenue growth in the most recent months or past year, unless there's been a new product or service that's been introduced. Business owners often try to channel stuff or front load revenue in order to make a business more attractive for sale. This growth may not continue in the future and may actually harm your growth in the first few months after the business is acquired. Another area you want to look at are the expenses. Look at the expenses very carefully to see whether they are consistent expenses that will continue after you purchase the business. Are there unusual one-time expenses that understate the company's true profitability? One type of expense to look out for is whether there are personal owner expenses such as vehicles, travels, salaries for non-working family members, or other types of expenses being run through the business. These add-back expenses are common in small businesses and must be verified, as they won't continue after you buy the business, unless you plan on running your personal expenses through the business too, which is not recommended. Don't forget, when looking at the expenses, that you want to include as part of your financial modeling to include the cost of any loan that you are taking out in connection with the business acquisition. You need to make sure that the business can support these additional loan costs before you actually purchase the business. Another area to look out for is any kind of unreported revenue that's being claimed by the business owner. Many small business owners don't report revenue they receive in cash, but will insist that this unreported revenue needs to be taken into account when determining the value of the business. Take any of these claims with a grain of salt and don't fall for it. You can't trust a business owner's claim about the volume of unreported cash sales, and you can't be sure that they will continue in the future. Another key area is the liabilities. Any liabilities reported on the balance sheets need to be investigated further as part of your due diligence to see whether they are being transferred with the business acquisition. If you're only buying the assets of the business, they may not be. But if you are buying the shares of the business, they will be. But either way, you need to get all the details about them to understand them fully and see whether they are ongoing and see whether you want to assume them. The next critical part of your due diligence investigation is the legal investigation of the business. You must ensure that the business is legally sound. This is where your business attorney's work is most critical and where I help my clients the most. Undiscovered legal issues can result in costly litigation or expenses down the road. Here are some areas that are essential to look at. The first legal area to investigate is corporate governance issues. You want to confirm that the company you are acquiring is in good legal standing with the state where it's formed, and that the seller has the legal authority to convey the assets or stock that you are acquiring. As part of this, you should look at the foundational formation documents for the entity, such as the Articles of Organization or Incorporation for corporations, Certificates of Organization for the LLC, any bylaws or operating agreements, meeting minutes, shareholder records, and so on and so forth. Most small businesses are terrible about corporate governance matters, but it is essential to confirm two things about the business you are acquiring. The first thing you want to confirm is who are the actual owners of the business. The second thing you want to confirm is that the sale of the business or the assets of the business that you're acquiring has been duly authorized by the appropriate party. This will prevent future headaches in the long run and make sure that the person you are buying from actually has the authority to sell the business that you're buying. The next legal area you want to look at are the business contracts. These are critical as they represent the legal framework of the company's relationships. You should review all material agreements, customer contracts, supplier agreements, licenses, employee agreements, real estate leases, and so on and so forth. When reviewing these contracts, there are three critical clauses to look out for. The first clause are what are called change of control provisions. Many key customer or supplier contracts have this provision, which says that the other party can terminate or renegotiate the deal if the company's ownership changes. Imagine buying a business for its relationship with a major client, only to find that the contract becomes void the day you take it over. It happens. You need to review every important contract to find these clauses and make sure the value you're paying for doesn't walk out the door right after you purchase the business. The second key clause to look for in these agreements are assignment or assignability clauses. This is a key clause, and you need to confirm that the contract can legally be transferred to you or assigned to you, hopefully without the other party's consent. If not, you might need to get the permission from every single customer, supplier, and possibly the landlord before the contract can be assigned to you as part of the deal. Or worse, the contract can't be assigned to you at all, and it is not something you can rely on after you acquire the business. The third key clause to look at in connection with these agreements are termination clauses. This is another key clause, and you want to make sure to understand how any of these business agreements can be terminated by either party, and whether there's a penalty associated with the termination. If you take on the contract after buying the business, you need to make sure and understand how you and the other party can get out of these agreements if necessary. Another key area of the business to investigate is the intellectual property of the company. For many businesses, their intellectual property, or IP, is one of the most valuable assets, and it's why you're buying the business. So you need to make sure that the seller actually owns whatever IP you are buying and has taken steps to protect it. For trademarks and copyrights, this means confirming that these are registered and owned by the company you are acquiring, and there are no infringement disputes. Usually for small businesses, the key thing to confirm is to make sure that the IP is not still owned by the founder, but is actually owned by the company who's selling it. And if the IP was created by a vendor or an independent contractor, you need to make sure that the ownership has been transferred to the business that is now trying to sell it to you. This has to be done by a written agreement, or there's a risk that the business does not actually own the intellectual property you're trying to buy. For trade secrets and other proprietary information, the process is a little more involved and complicated, because you need to make sure that the seller has taken reasonable steps to protect this information. And this includes making sure that the seller has used things like confidentiality and proprietary rights agreements, which are commonly called NDAs, and taking other steps to make sure the information has not been passed around without adequate protections. If the key information has been passed around freely without adequate protections, its value could be near zero. Another key area that needs to be investigated is whether there are any liens on any of the assets of the business that you are acquiring. Liens can come from many different sources, such as contractual agreements, like a loan from a bank or the government, such as a tax lien from the federal or state government, or civil litigation judgments. No matter where it came from, any liens on the assets of the business need to be resolved by the seller before you buy the business, or they can be resolved in connection with the proceeds from the business when you're acquiring it. Otherwise, the assets are still subject to the lien and can be potentially sold by the creditor to pay for the debts owed by the seller even after you own them. Another key area that needs to be investigated is with respect to the employees of the business you are acquiring. Employee issues are often a top reason acquisitions fail, yet they are often glossed over. Here are some of the key things you want to take a look at. First, you want to take a look at the employment agreements and the bonus plans and benefit plans to ensure you understand exactly what the employees are expecting. Nothing can kill employee morale quicker than changing bonus plans or benefits for the worse after you acquire the business, or reducing the salaries of the employees after you acquire the business. The next thing you want to look at is you want to look for any potential employment law violations like unpaid wages or misclassified independent contractors. Past violations may not hurt you if you're only buying the assets of the business, but future violations can be, and they are expensive. So think 3 times what's owed to the employee plus attorney's fees. The other thing you want to check to make sure is you need to make sure that all key employees have non-compete or non-solicitation agreements, so that the employees can't walk out the door after you buy the business and start a competing company or solicit your clients. Also, be on the lookout for high employee turnover. It can signal a toxic culture or poor management, and it can make integration difficult. Another key area to investigate is whether the business you are acquiring is involved in any pending or threatened litigation or government investigations, and whether it has a history of regulatory fines or violations. Sellers will not usually volunteer this information, so you need to investigate it as much as possible and specifically ask for this information from the seller. If you're only buying the assets of the business, you may not be overly concerned. But if you are buying the shares of the company, this information is absolutely critical to know so you are aware of the potential for any future liability. Now, I know this is a lot to follow, and keeping it all straight will be a challenge. To stay on top of these issues, keep learning. And if you found this information valuable and helpful, please hit the like button and subscribe to the channel Small Business Legal Tips for more practical strategies to protect your business. So once you've completed all your due diligence, what do you do with all the information? And there are really only 2 options. The first option is that you can terminate the deal. It is absolutely critical that every purchase agreement has a contingency clause in it that allows you to terminate the agreement if you don't like what is discovered in due diligence. Usually these agreements will have a due diligence deadline with a specific date when all due diligence needs to be completed by. Along with that date, you should have the right to terminate the proposed deal without penalty for anything you discover. The second option you can take in connection with what you learned in due diligence is that you can use what you discover as leverage for negotiating a better deal. And there are some options you can take. The first option is negotiating a lower price. If some assets are not as valuable as you originally expected, or there are significantly higher expenses or potential liabilities associated with the business, you could negotiate a lower price with the seller. Another option you can take is to revise the purchase agreement to include protections in the representations and warranties clause. As part of your representations and warranties clause, you can force the seller to formally guarantee the specific facts about the business are true. And if they turn out to be false, you have a legal path to recover your damages. Make sure that these clauses survive the closing. There should be a provision in the purchase agreement that states that these representations and warranties survive for a certain number of years after the closing. And the period should be for at least 1 to 2 years, but it can even be as long as 6 years or more for more important clauses that need to survive for longer periods of time. For more specific risks that are known or discovered, like a pending lawsuit, you can also renegotiate the indemnification provisions of the purchase agreement so that they cover the cost of these risks. This will require the seller to cover your costs in connections with any specifically identified risks and that they have to pay for them going forward. Another option is to negotiate an escrow or holdback clause where a part of the purchase price is held in an escrow account and be accessed by you under certain conditions, and that you'll be able to access the amount by following a certain procedure without having to resort to litigation. Another option is that for really critical contracts, such as a lease, you could insist that the seller gets the necessary consents and assignments from the other party. And you should make sure that these consents and assignments are obtained from the other party before a single dollar changes hands. And the way you do this is by including as part of your purchase agreement a condition of the closing that these consents and assignments have been obtained. So to recap, remember the purpose of due diligence is to find all the material facts to make sure the business is worth your investment. It is far better to learn about any issues before you buy the business and save yourself future headaches or loss of money. Thank you so much for watching. If this helped you, please hit the like button and subscribe button and ring the bell. Drop any questions you have in the comments below or make some suggestions about other topics you want me to discuss. I'm here to help. See you in the next one.